Okay.
Namaskar, sir.
Namaskar. Please introduce yourself.
So my name is Sudatta Panigrahi, and I've completed my graduation from SO National Institute of Law, and currently I'm preparing for judicial service, and I belong to Kemjar.
Okay. How a suit is instituted?
Suit is instituted by presentation of a plaint in the court.
In which court it is to be presented?
The general rule is it has to be instituted in the court of the lowest grade with reference to the pecuniary jurisdiction, and the person must also be the suit must also come in the territorial jurisdiction. So these all things are taken into consideration.
What is interpreter suit?
Um, I'm unable to recollect the order, but interpreter suit is basically when there is a matter in which a person himself has no interest in that particular suit, in that particular movable property, immovable property, or money, or whatever. But for he does it for the other two parties, so that the honorable court can decide that the property or the money it belongs to which person, and whatever money he has given in the sense that whatever expenses he has done, he can recover it.
What is the procedure for filing a suit against the government?
The suit can be filed against the government by issuing a notice of 2 months to the party. And once that notice is given, it is a duty of the competent government authority that he goes through that particular notice, and if the matter can be resolved, he will resolve. Otherwise, a suit will be instituted, and thereafter, a period of 3 months is given for the execution of that particular decree.
X intends to file a suit against the government.
Yes.
That is, say for collector X, collector Cutter. He issued a notice under section 80 of the CPC today, and after 2 months, he instituted a suit against the collector. Whether that suit is maintainable?
Yes, it is maintainable, but if it has to be seen when suit is against the public servant, it has to be seen that whether it is done in personal capacity or in official capacity. In case if it is done in personal capacity, then a notice period is not required. Suppose I have some personal issue with the collector, then I don't have to give any sort of notice. But if it is in some official capacity, then notice is to be given.
How issues are framed in a suit? On what
By
basis issues are framed? On what basis issues are framed?
by the avertments of the plaint that has been given.
What is judgment?
Judgment is defined under Section 29 of the Civil Procedure Code. It says that it's basically the definitive decision of the court that is given. Elaborately speaking, it's the elaboration of the case that is given, and also it includes the points of determination and the rights and liabilities, whatever is decided, that is there in the judgment.
What is review under the civil procedure?
Review is basically Review is basically done by that same court which passed the judgment with regard to the matter and issue that is being decided. I'm really sorry, sir.
What is revision in
Revision
CPC?
is basic. Revision under
Under
CPC
CPC.
is done by Honorable High Court in case if jurisdiction is given and the lower court is not exercising this jurisdiction. In that case, Honorable High Court can see that whether the jurisdiction is properly exercised or not, or whether he has exceeded or something. So it is basically related to jurisdiction.
What is second appeal?
Second appeal is done to the Honorable High Court under Section 100 of the Civil Procedure Code, in which there is any substantial question of law. In those cases, a second appeal is done.
There is an error in a judgment. Can it be corrected by the court?
Yes, it can be done by. Yes, it can be done.
On all types of errors.
No, it's basically clerical mathematical errors or minor errors, not major ones.
What is substituted service of summons?
Substituted service of summons is dealt under section under Order 5 of the Civil Procedure Code. In case if a defendant refuses to take the summons, or if he neglects or refuses to take the summons, in that case it is fixed in the conspicuous part of anywhere he is residing, and then the presiding officer he signs, and it kind of becomes a valid proof that the summons is duly served to the defendant.
When a suit is to be disposed of at the first hearing,
Sorry, sir, I'm unable to. Connect.
suppose a party did not file a list of the documents along with the plaint or the written statement, will he be permitted to file those documents, give and produce those documents in court?
Sir, I'm not really sure, but I think yes. It may be allowed for the interest of justice. I'm not really very sure about this thing.
What is the inherent power of the civil court?
So, for the interest of the justice, whatever possibly can be done, that can be done by the Honorable High Court.
It's okay. Let us come to IPC. What is AFRE?
So, AFRE is basically when two people they fight in public place and disturb and create any sort of disturbance in public place. That is known as an AFRE.
What is abduction?
Abduction is an auxiliary act. Um, uh, Sir, can I take a minute? Um,
Okay.
Sir, I'm just unable to
What is
recall
kidnapping?
that. And,
What is
kidnapping is
kidnapping?
basic. Kidnapping is basically can be broadly categorized into two. One is kidnapping from India, when a person is taken outside the local limits of India. That is one sort of kidnapping, and another one is kidnapping from lawful guardianship, when a male of 18 years or female of 16 years is taken out of the lawful guardianship of the lawful guardianship of that parent, then we say that the offense of kidnapping is done. However, there has to be also an element of taking and enticing.
What is writing?
Rioting is nothing but unlawful assembly with violence.
What is cheating?
It's dealt under Section 416 of Indian Penal Code. Unable to recall this thing.
If a Mohammedan woman, a Mohammedan woman is liable for bigamy,
Sir, if we go by the personal law, then it is not allowed that a Mohammedan Muslim woman can have more than one husband. Uh, as per, if we go by the law of the land, then IPC is a secular law, then she can be held liable because it's not there in the personal laws. I'm really sorry. I don't know the exact one, but I think she can be made liable.
What is custom and usage?
Custom is something which is been followed for a long period of time, and there is no interruption, something like that.
If somebody says there is a custom in our locality to marry the daughter of the father's brother, is it permissible?
It is permissible if it is being done or continued for a long period of time. If it's followed in that particular community, then yes.
Suppose a Hindu man says we have a custom to marry more than one wife. Is it permissible?
No, because as per this, if I go by the explanation that is provided under Section 5, it says that if it's like in prohibitory decree or in secondary relationship, if the custom allows, then it is allowed. But nothing as such
But
is mentioned in nothing as such is mentioned in terms of Section 5, subsection 1, in which this can be done. And as such, it is a punishable offense under Section 494 of Indian Penal Code.
what is intestate succession?
Interstate succession is basically governed by Hindu Succession Act, wherein there is there is um, no will or something is done like it's an automatic way of inheriting the property after the death of the person.
A Hindu woman was given a piece of land for her maintenance.
Mm.
Thereafter, that woman sold that land. If the sale is valid,
So Hindu woman,
was given a piece of land for her maintenance.
yes,
Thereafter, that Hindu woman sold that land.
yes, this is valid because it's given to her. She becomes the owner of that property.
No, only for maintenance that property has been no transfer. There nothing, no document was there. Simply
Then,
orally
then
a piece of land was given to her by simply
no,
writing a document, whether it is valid or not.
no, it can't be. It is not valid.
A, a Hindu girl married, and soon after marriage, she was going to the house of her in-laws. On the way, there was an accident. She died.
Mm.
Prior to that, she had inherited a property from her mother.
Mm.
Then the husband claimed the property of that deceased woman. Will he succeed?
Yes, because that will be treated as a separate property, and after her death will be. But sir, I don't know the answer. I mean correctly, but can I try?
Okay, try.
Sir, actually, if we go by the provision, whatever she inherits from her father's property, from her father's side, in that case, it will go back to her father. Uh, um, Father, I mean, whatever she has inherited, and whatever she has inherited from her husband's side, it will go back to her husband. So, in this case, if we apply this law, then I think that it will go back to her mother and not to his husband. Not sure.
What is the difference between void marriage and voidable marriage?
So void marriage is a marriage that is completely void that if it comes under the category of section 5 subclause 1 subsection 1, 4 and 5. And voidable marriages are those marriages which are not void by inception. For example, when the husband is impotent or is suffering from any communicable disease or has renounced the world, in those cases it is a voidable marriage.
Whether the child born from a void marriage or voidable marriage will be treated as legitimate child.
Yes, if, he will be treated as a legitimate child.
What is lease?
So lease is a mode of enjoyment that is given in a certain property. In return of that, some premium or rent is paid. Exact
What is
definition.
right of redemption?
Right of redemption is an inherent right in which the mortgagee, the mortgager, he can redeem back his property after paying the mortgage money.
What is equitable mortgage?
E- Equitable mortgage is um, no sir, I'm unable to recall this.
What is gift?
Gift is a transfer of ownership without any consideration in between two living persons, dealt under Section 122 of the Transfer of Property Act.
A particular offense is punishable with 1 year imprisonment.
Hmm.
What is the limitation? Is there any limitation for taking cognizance of that offense?
It's up to 1 year, then it has to be brought within a period of 1 year under Section 468 of Criminal Procedure Code.
Can that delay be condoned?
Yes, if sufficient grounds are shown that why it was not brought within that period of 1 year, then it's subject to discretion of the Honorable Court.
When a magistrate can issue a search warrant,
The magistrate can, under Section 96 and 97, in case if a female is abducted, in that case also he can, if it is given on oath, he can issue a search warrant. Or under Section 96, a general search warrant he can issue.
first is doctrine of double jeopardy.
Doctrine of double jeopardy says that once a person is acquitted or once a person is convicted or acquitted, he shall not be tried for the same offense again.
Cannot be tried at all. If a person has been acquitted, can he be tried
Mm.
for the second time in on in occasion?
So in that same facts, then no. But if the
Yes, based on
honorable,
the same fact.
no.
In which can a public prosecutor appear before the magistrate?
Mm, no. No. Uh, um, I think no. No, sir.
What is fact in issue?
So fact and issue is when one fact is asserted by one party and another party denies the fact. In that case, it's a fact and issue.
When a fact is said to be disproved,
When it is given under Section 6 of the Indian Evidence Act, if I'm not wrong, it says that when the fact is neither proved nor disproved, that case it is. known as not proof.
What is conclusive proof?
There are certain facts in which the court is not entitled to exercise his discretion. In that case, the court is bound to believe in that particular fact, then we call it as a conclusive proof. Like birth during the marriage, if within 280 days of marriage, if the child is born, then it is a conclusive proof that the child is a legitimate child of those both husband and wife.
What is a document?
Document is dealt under Section 3 of the Indian Evidence Act. It says that anything, um, it can be anything which is inscribed, um, maybe it maybe on any document or any lithography or any stone or whatever is inscribed, that is there. Exactly, I don't remember, sir.
Document is also defined in Indian Penal Code. Similar, there is
Yes.
a document of definition in the Evidence Act. What is the difference between the definition?
I think the document that is given under the definition of document that is given under Indian Evidence Act is much more wider in comparison to the ones that is dealt under IPC. Like here it contains, like if anything is also engraved in stone, then that is also taken into as a document under the Indian Evidence Act, but not in case of Indian Penal Code.
Okay. I will give my feedback after your second round of interview is done.
Okay, sir.
Good afternoon. Good afternoon.
Hmm.
How are you?
I'm good, sir.
Yes. What is your roll number?
It's 301486.
Can you tell me what rings the bell? I mean, what do you get reminded of when you hear the number 301 in law?
Sir, it's Doctrine of Transfer of Malice under Indian Penal Code.
And
And sir, I can't remember anything as of now. No, it's no.
okay, no issues. Uh, Next is, can you tell me who is a co-partitionary?
So co-passionary is a narrow concept that is dealt under in the Succession Act. It's like four generation. Um, Now it also four generation of family members are now included. Now it also, after the 2006 amendment, 2005 amendment, now the daughters are also included as co-partners.
Whether Evidence Act is applicable to arbitration proceedings?
No, it is not applicable to arbitration proceeding.
Can you tell me uh, what is a prima facie case? What is a prima facie case?
Mm, Prima facie case, it's like after going through the facts of the case, it's preliminarily we can have this kind of um, we can ascertain or we can believe that this case is in favor of that person who has brought in the case for the purpose of temporary injunction for filing of the for filing of the temporary injunction.
Okay, whether a wife who is a lunatic and also divorced, she can claim maintenance under section 125 CRPC.
Yes, she can.
She can.
Yes.
Okay. What do you understand by escheat?
when there is no one who can claim the property, in that case, it goes back to the government of that particular state for the land, and that is known as estate.
Purpose of inquiry under section 202 of CRPC?
The main purpose that is it's a preliminary inquiry done to ascertain the facts.
Okay. Okay. Please comment on Shahbano's case regarding the maintenance of a Muslim woman.
Earlier, it was the main contention that was placed before the Honorable Supreme Court was that whether the Muslim woman, this the dower amount that is given to the Muslim woman, whether that can be that can be equally calculated that is equal to the maintenance or not. So it was held by the Honorable Supreme Court that no, it is the dower and the maintenance, they are both different things, and a woman is entitled to claim maintenance under the Criminal Procedure Code because it is a secular law, and there is no provision, no prohibition that she cannot claim maintenance under CRPC, because it is not allowed in that their personal law.
Yes. Can you tell me whether a police report can be considered a complaint?
Yes, when it discloses a non-cognizable offense, in that case it can be.
What is a trade design? Trade design.
Sorry, sir, I won't be able to answer this question.
Can you tell me what is a patent?
Patent is a right that is taken in case of certain product or something is there, and one kind of patents it under the Copyrights Act. So, sorry, sir, won't be able to get the exact answer.
Okay. Can you tell me a circumstance in which a trial can be held in jail?
Uh, yes, in case if it is involving any high profile case, if it is there, then in those cases, like there was a particular case that I don't remember the name, wherein the honorable judge he went inside the jail to pronounce the sentence to the accused. I don't remember the name, but yes.
Okay. You have done your LLB back in 2018, I believe.
17, sir.
17.
2000.
17. And don't you think, um, I mean, since then you have not done anything. Don't you think you have wasted a lot of years? Because you would have done anything else.
Sir, I was given judiciary exams. Unfortunately, I was not able to clear a few stages. Like in mains, sometimes in mains once I could not clear, and this time when I qualified these 3 rounds, I could not clear the cutoff. So it's been my passion. So I'm trying very hard to achieve this goal. So I'm dedicated this thing.
It's nice to know that. Uh, okay. Can you tell me there is a principle in Limitation Act called dura lex sed lex. What does that mean?
No, sir, I have not come across this term. I am not able to
Dura lex
answer
sed
this.
lex you have not done?
No, sir.
Okay. What is a privity of contract? What do you understand by privity of contract?
That no third person can bring any sort of like if a contract is subsisting between two parties, then third party cannot come and say anything about that contract. Or something.
Okay. Uh, can you tell me what do you understand by doctrine of necessity?
Yes, doctrine of necessity. We it's like to prevent a greater harm. If a small harm is done, then that is not taken as an offense under the Indian Penal Code. Rather, it comes as under the general defense category. Like in the it was also held in the case of R versus Dudley Stephen, wherein the doctrine of necessity was broadly discussed.
What is the evidentiary value of a confession made before a doctor?
It will be treated as an extrajudicial confession.
Whether we can base that to make a conviction?
It can be used, but as a corroborative evidence, we have to take other evidences as well into consideration.
What is the proximity rule that is used to determine the distinction between attempt and preparation?
Sir, sir, I only so there are few. No, no, sir, I won't be able to answer this.
Okay, just tell me how will you distinguish between preparation and attempt?
So basically it's a second stage of the crime in which a person like he has some mens rea and if he does any act in furtherance of it, then we call like he prepares something. Then it is like say for example if he brings poison, then we will say that okay he has done the preparation. The moment he mixes with in the food, and then we call it as an attempt is done. And then if he dies or some consequences happen, then we say that the crime is committed.
Can you tell me the latest case on marital rape?
So as such, there was a there was a particular. It's not dealt particularly as to marital rape, but Honorable Supreme Court has taken this thing into consideration. But I'm not able to recollect the name of that particular case. But yes, it was discussed in our case.
Okay. There is a group, and in that group there is a woman. The group now they were partying in a picnic, and they saw one girl who was moving, and in the because they were drunk, all of them, so they committed gang rape upon her. Now, whether this particular lady who is part of the group, he can be punished for any offense.
Lady cannot be punished for it.
So we'll just let
Or,
him go, let her go, even though she has done been a part of that group.
uh, she cannot be she cannot be held liable for the offense of gang rape. But there was a particular judgment which I read back recently only, wherein um, it was told by some high court judgment or somewhere that she cannot be convicted for this offense, but we have to take into consideration regarding that whether she has participated or not. Like what is the amount? What is her degree of participation in that particular offense? Whether she was actively doing something or not, or kind of something. And I don't recollect this one.
What was held in the famous case of Rajnish versus Neha?
No, sir,
It
I'm
relates
not
to
able to.
it relates to the maintenance. Hint is it relates to the maintenance.
No, sir, I don't remember.
Okay. Uh, Now, tell me, I went inside my friend's house with the intention of killing him, and then I put a pillow on his face. Okay, and I entered his house at 11:30 p.m. and then I put a pillow on his face, and with the intention of killing him, and presuming that he is dead after 5-10 minutes, I came back. Later on, a later on when the postmortem report came, it was held that it was given in the postmortem report that he was already dead. He was already dead at 10:30 by virtue of a heart attack. And I went to his house at 11:30 in the night. So basically, I have tried to kill a dead man. What offense shall I be punished under?
So, an offense cannot be committed against a dead person, but will this be taken into account as an attempt or not? That is, I don't know, sir.
Okay, okay. A person finds a ring on the road and he picks it up and puts in his pocket. What offense does he commit?
If it is an
Yes, you got stuck. Tell me.
yes, sir, my internet. Sir, if he finds it on the high road, then it's not no offense is committed.
And if it is finds in the low road, then
So if he finds in the low road, then not in the low road, in the highway. Sorry, sir, I said high road. Then
okay.
it's not an offense. But in case if he finds it anywhere else, then he has to take steps to find out that who is the real owner. Otherwise, he'll be held punishable for criminal misappropriation.
Okay, okay, great. Can you tell me what was held in the famous Shreyas Singhal case?
Something related to freedom of speech and expression. Uh, exactly, sir. I don't remember. Something related to freedom of speech and expression.
Yes, yes. Okay, okay. Thank you. I'll come to your feedback after Sir gives the feedback. Thank you.
So,
Okay. My first question is how suit is instituted. Suit is instituted by presenting plaint in the lowest court competent of jurisdiction. That is correct. Suit is instituted by presenting plaint in the court competent to try it. Then who is competent? Always suit is being instituted in the lowest grade of jurisdiction. Every court has territorial and pecuniary jurisdiction, lowest grade. Try. Interpreter suit. Interpleader suit means when two or more persons make rival claim of any property or debt from another, and that another person has no right, does not claim any right in that property, but is prepared to deliver that property to the rightful owner, then that person, the other person, can file a interpleader suit against the persons who are making rival claim to decide as to whom he will deliver that property. This is called interpretership. Concept two or more persons making rival claim of a property or debt from another, and the person who is holding that property has no right, no interest in that property. He is prepared to deliver the property to the right place. So, in such case, that other person may file an interpreter suit against those persons who are making rival claim. In such event, there will be pleader. Both the defendants will plead as to who is the rightful owner. Suit against a government, no suit against government or public officer for their official capacity, for any act done by their official capacity, will be filed unless 2 months notice is delivered from the date of delivery of the notice. So here my question was sent a notice and after 2 months. No, the delivery date is to be taken into consideration. Whether that notice was delivered on which date. If not, it has left in his office. It has been delivered in his office. Then thereafter, after 2 months, that suit is issued. Sometimes you commit mistake by simply sending notice. No, sending notice is not there by delivering the notice to the person as required under Section 8. So issues are framed on taking into the pleadings. Pleadings means both plaint and written statement. Not only plaint and written statement and hearing the parties. Judgment means any statement given by a judge regarding the decision of a case is called judgment. Statement given by a judge while deciding a case is called judgment. That is defined.
Judgment.
Review means what? After passing of a judgment, the person who is aggrieved, even if appeal is allowed, but without preferring appeal, or when there is no appeal is preferred, then he can file a review petition to reconsider that judgment on the ground some new evidence was found, some other procedural reasons are there. That is called review. Revisions mean that High Court on the decision, both powers are available. Well, for the record, when the court has exceeded jurisdiction, failed to exercise jurisdiction, and acted with materiality on the three counts, this revision is there. Second appeal is always to the High Court on the point of view, never on fact. Point of view. Error in judgment, the clerical error that can be rectified at section 152 perhaps, that is of the CPC, that is substituted service is always to the defendant. When the defendant refusing not is keeping him away to avoid receipt of summons, then only substituted service will go. Avoiding service from a summons. These three words you have to remember. You have to remember. Then one copy of the summons will be affixed to the court notice board and on the conspicuous part of the house where he was last used. Or in such other mode, at the court duty, that means either publication by newspaper or by beat of drums, the court directs, not mandatory, publication of newspaper is not mandatory. If the court directs, so that will be published in a newspaper widely circulated in the locality where the defendant was last residing. You might have seen many advertisements under Order 5 Rule 20 of the CPC in various newspapers every day. But it must be mentioned that you are avoiding to receive summons. That is. To dispose of at the first hearing when the parties are not in issue. Parties are not in issue, then the suit is to dispose of at the first hearing. Then list of documents must be presented along with the plate, etc. If that has not been made, then with the leave of the court, subsequently with the leave of the court, those documents may be admitted in evidence. After two or more persons fight in a public place, disturbing public peace, that is after. Abduction means whoever by force or by deceitful means compels or induces a person to go from, by force compels or deceitful means induces that person to go from any place. That is abduction. Kidnapping are two types. One is kidnapping from India and kidnapping from lawful guardianship. Kidnapping lawful guardianship, if a person, a female below 18 years of age and a male below 16 years of age, or an insane person is taken out of the lawful custody, guardianship of that person, then that is kidnapping from lawful guardianship. Whoever conveys any person beyond India without that person's consent, that is called kidnapping from India.
India.
Writing, I put a question, when force or violence is used in unlawful assembly or by any member of the unlawful assembly in prosecution of the common object of that assembly, then that is writing. Cheating. Cheating rate, you have to always remember a keyword, concealing. Whoever by concealing anything, fraudulently or dishonestly induces a person to deliver any property or to retain any property which would have not retained because of such concealment or inducement, he retained that property. That is cheating. Causing what? Fraudulently or dishonestly. Two words are there. And that is when it damage, harm, etc. That is cheating. Yes, bigamy is applicable to Mohammedan women. A Mohammedan man, if marries more than one wife, then that bigamy is not applicable to Mohammedan man. But to a Mohammedan woman, because that law doesn't permit her to marry during the lifetime of her husband, polyandry is not there, not allowed in Mohammedan law. So that is why the Mohammedan woman is liable for bigamy. Custom and usage. Custom and usage has been, they say one same definition in Hindu Marriage Act and also Succession Act, that is, any rule which has obtained the force of law, any rule which has obtained the force of law in any locality, any area or any family, that is custom. But it must be custom for the difference between custom and usage. Though same definition is there, usage is a rule repeatedly followed. Custom is that usage which has followed from time immemorial. That is for a long period. Then that is a custom. But custom and usage will find a similar one definition in that any rule. That's not marrying because custom must not be opposed to public policy. It must not be unreasonable. So here unreasonable. Marrying somebody's father's younger brother's daughter. That is not permitted. So the maternal uncle's daughter, that is permitted. That is permitted. Custom. Intestate succession, that is a person who died without executing a will, his property is to be succeeded as intestate succession. So, intestate succession. A person died without executing a will, that is that succession takes place, that is intestate succession.
Interested
So far
succession.
as Hindu woman is concerned, section 14 we find any property possessed by a Hindu woman as per the commencement of Hindu Succession Act in any capacity, that will be treated as her separate property. She will be treated absolute owner of the property. If by writing some property has been given to that Hindu woman for her maintenance, if she is possessing that property, that will be treated as her absolute property and she can alienate. This is, you must be conscious about section 14. That is Hindu any capacity possession. Then husband claims property. If the property has been inherited from father, that will go to the heirs of the father in absence of children. Void marriage, any condition, three conditions. That bigamous marriage, having one spouse marriage, and prohibited relationship marriage, and subpoena relationship. Now let's discuss it. Their marriage is a void marriage. Voidable marriage is that marriage that is likely to, marriage was not consumed due to impotency or some other cause is that marriage is there. If the agreed party chooses, she or she may continue that marriage. So long it has not been declared for that marriage will proceed. That is the limitation, as I told you, that is what is fact. Public prosecution, assistant public prosecutor is engaged in assistant. Public prosecutor is engaged fact in issue, any fact from which either by itself the existence, non-existence, nature, liability of right, liability, and disability asserted or denied. That is called fact in issue. This proof you fail to remember This proved if the material, if the court on considering the materials will find
And
that it does not exist. That is his
that's not
proof. Then
I also.
conclusive, conclusive proof, three words, conclusive, may presume, shall presume, conclusive proof. Three words you have to remember. Declare, directed, declare, this provided, directed, declare. So far may presume is concerned, wherever it has been provided in the court may presume, court may regard such fact as true, or may confirm the provided, directed. Whenever it is directed that the court shall regard such fact on which this is true. Conclude that directed, declared. When it has been declared by one fact is the conclusive proof of other fact, then on proof of that fact, the other fact is proved and no evidence will be allowed to be like they gave you example that during substantial marriage a child is born or the 280 days after the dissolution of the marriage, that is a conclusive proof regarding legitimacy. Document. Document any matter expressed on any substance by means of letter, figure, or mark, or by more than one of those means, intending to record it. That is in Evidence Act. But in that is IPCL, there is similar definition which may be used as evidence. First document is created. Any matter described any substance by means of which may be used as evidence. That is the difference. Anyhow, you have some clarity. That is, before, unless a section is asked, why you are confusing yourself? Why you remember
Sorry,
by
sir.
producing the section? Section is not
Sorry.
there. Section once it is simply remembering. You have to find out section by referring to books. How far you understand the concept? By remembering, by making your mind exercising your mind to recollect your memory regarding the section, you are committing some mistake. Section may not be
Sorry,
there.
sir.
Section, it is not your, the person cannot buy out all these sections. So you are, unless you are asked to say section, why you are saying section? So
Sorry,
your
sir.
concept is clear. Never repeat, thereby you are unnecessarily puzzling your mind. And you have the good personality, be also okay, you go with confidence, you may.
Yes, Sudatta, I see you as a potential candidate who will clear the interview this time. Having said that, yes, as sir pointed out, you puzzle yourself by posing
Um,
questions to you yourself only during the answer. Okay, so
yes, sir.
that I keep saying that you are your biggest enemy. So please know that
I'll not do it.
I see that there is conceptual clarity. You know the answers. Sometimes you puzzle yourself, and in the process, the interview goes in other territory. Some question you could not answer, I'll tell you about it. Proximity rule. Proximity rule is with relation to attempt and preparation. So, how proximate it is to the crime, according to that, it will be attempt or preparation. Whatever you said, the example you gave, but you could not say that it is proximity rule. Okay. Now,
Mm.
whether I can kill a dead man and be punished for it, like I went into the house of my friend, there I can be at best punished for attempt to
Attempt.
murder. Attempt
Second.
to attempt to murder. So
Attempt.
attempt of 307. You're getting it? Because
Okay.
it will not be attempt to murder, it will be attempt to murder. So attempt of 307, 307 read with 511. Okay.
Sir,
Now,
but I've
yes,
never come across this attempt to attempt this thing, so
yes,
I
yeah.
come
Please read
across
about
this.
that. In 511 only, if you read any good book, this example is given.
Oh,
I think,
this example I remembered, but I was not sure whether it will come or not.
okay, okay. And now, whether woman can be guilty of any rape or anything? No, he cannot be guilty of rape. But Om Prakash versus State of Haryana, Supreme Court said that yes, she can be guilty of abetment of rape.
Up
Abetment of
and
rape.
down.
Okay. Then Dura lex said lex, that is law is hard, but it is law because limitation act is sometimes very causes very hardship to people. Like the 25, 26, 27. It says that you lose a right. 27 says that you lose a right. over your property because you are not vigilant enough for these many years. So that's why to mention that Duralex said lex is law is hard, but it is law. Okay. Now trade design is nothing. It is like a trademark, but it is in this. It is a particular shape or particular icon or particular design that is used as a trade design. Okay. Here no symbol is used, but shape like the shape of Coca-Cola bottle. Coca-Cola, the
Mm.
glass bottle that was coming, that was of a particular shape. So likewise. Okay. Now trial in jail, yes, trial in jail can take place when High Court permits and pers- the accused consents to it. The accused consents to it and High Court permits, excuse me, then a trial in jail can be committed. Now, privity of contract, you said that, but again, you got little flustered. You did not complete your answer. Privity of contract, when a party is not a party to the contract, he is not a party to the contract, he has no say in it. So, if you are a party, then you have some say in the contract. That's what privity of contract means. Now, doctrine of necessity, you mentioned. Now, Rajneesh versus Neha. Rajneesh versus Neha is a famous case of Section 125 maintenance where there are guidelines given to fix the quantum of maintenance. Fix the quantum of maintenance. The guidelines are given. Okay. It is also asking for a asset liability statement in the shape of affidavit to be filed so that the quantum of maintenance can be found out. Now, marital rape, the recent case is RIT Foundation versus Union of India. RIT Foundation versus Union of India is the case on marital rape, which now says that yes. Now, what else? Trade design gone, proximity rule gone. Yes, that's it. That's Shreya single case. Shreya single case is relating to 66A. 66A is in contravention. 66A of IT Act is in contravention of Article 19(1)A. So freedom of speech and expression. Yes, it violates 66A violates so, and that's why there was a girl who posted something on social media, and that was challenged, and she was arrested for the same under section 66A. She challenged the same, and there it was held by the Supreme Court that it violates the Article 19(1)A. 66A was held unconstitutional. Okay, so these are some of the questions that you could not answer. But having said that, you are not expected to know everything. Just that don't be puzzled. Sometimes you know it, but halfway you are leaving the answer.
Yes,
That
sir.
is not expected. Complete the answer, okay? Because I'm telling you that yes, you might be a fighter, then that's the reason since 4 years you have kept this fight alive. But I'm telling you, the more the time passes, the zeal will go less. I mean, it will become less. So that's why you try that. This is our best chance, and within this chance only we have to clear it. Okay, you revise more. When is your when is your final interview?
20th.
20th. So we will schedule your third mock, which will be final mock around 17 or 18. Okay.
Sir, one issue that I'm finding within myself is that sometimes when I'm answering, automatically my brain is becoming blank. Like I don't know what to speak or
So
become. Is it because
in that case, what you can do is you can simply say, "Sir, may I take a few seconds to frame the answer?" And then you take a pause. It will not happen always. It happens sometimes, but then when it happens, at least you take that buffer time from the panel. You say that, sir, may I take a moment or may I take a few seconds to frame the answer? If they say, they will in all probability say yes, and then you take the time and aram say you frame the answer and then you tell them. Okay.
like the question that was asked, like abduction, a very simple concept. I could remember that it is an auxiliary act, and at that moment I was completely blank. Even though I took 1 second break, then also I could not recall what was there in that
If
provision.
sometimes that might happen, you might not recall, then you can't waste like 2 3 minutes of the interview. You will
Yes,
simply
yes.
say that beg your pardon, sir, I'm unable to recollect. I've gone through it, but
Mhm.
I'm unable to recollect right now. That you might say. It's okay. It happens. Okay. But whatever may be, you maintain your I see that you maintain your composure very well. So carry that to the interview and you'll be good to go. No issues. Okay.
Okay, sir.
Okay. Thank
Yes, sir.
you.
Yes,
Thank
sir.
you, Mahendra. Thank you. Namaste.